Hello, I'm Shanti. Today we will be doing the Corporate Law MOOC course. Under this course, today we will be looking at corporate governance in Indian companies. What are the objectives of this particular module? The first objective is to understand the concept and importance of corporate governance. The second important objective is to understand what are the issues in corporate governance. The third objective is to understand what are the provisions relating to corporate governance under the Companies Act 2013. The other and the final objective is to understand what are the requirements of clause 49 of the SEBI's listing agreement. First, let us look at how did the corporate governance emerge. During the beginning of the 20th century, we had a lot of illegal and unethical corporate business practices of the high-profile business companies. We can take, all of you might be knowing about the Enron issue that had happened during the mid-20th century. Now, this resulted in the requirement of good governance practices. So, actually, the Enron and the various scams, it shocked the business world. What is happening? You need to have good business practices. You are playing with the money of the shareholders. And for this, you need to have good business practices. And so this resulted in the requirement for having a very good governance principles. And this led to the thought process that fair and transparent mechanism has to be evolved to run and administer the corporation. So this fair and transparent mechanism that the businesses they try to evolve were based on 4 principles, and this basis of which the fair and transparent mechanism emerged. The first pillar was accountability. That is, the company should be accountable for its action. The company should adopt fairness in its dealings. The company should be transparent in its dealings. The company should be having independent authority. The directors, that is the CFO, these executives, there should be an independence in the functioning of the company. So, the 4 pillars of corporate governance are accountability, fairness, transparency, and independence. Now, let us look at what is the definition of corporate governance. So, corporate governance basically, as you would understand, is a fair and transparent mechanism to run the business. According to the OECD, the definition given by the Organization of Economic Council and Development, corporate governance lays down the procedures and processes according to which the company is controlled. Corporate governance is also a set of relationships between a company's management, its board, its shareholders, and other stakeholders. Now, what are the issues under corporate governance? What all would come under corporate governance? How do you distinguish between the board and the management? What is the composition of the board of directors and related issues? What is the role separation? I mentioned earlier, independent CEO and the chairman of the company. What are the remunerations of the directors? What should be the disclosures that should be done by the company? What should be the auditing process? how would you protect the shareholder rights and their expectations? What would be the role of the institutional shareholders? What would be the role of the investors? Now, these are some of the issues under the corporate governance. These are the issues that basically is taken care of in the corporate governance. Now, let us look at what is the importance of corporate governance. If a fair and transparent mechanism is followed, how does it help the company? It helps in the prosperity and progress of the company. It showcases the integrity of the company. It creates wealth through legal and ethical standards. The benefits of corporate governance are that it will help the company in maintaining good relations with the various stakeholders, its various stakeholders. It would provide protection to the interest of the shareholders. It would help in giving confidence to the investors. It would help in increasing the value of the corporation. It would ensure that the laws of the land are complied with. You are more into compliance with the legal and the ethical standards. Now, let us very briefly look at how did the corporate governance emerge in India. As you know, during the periods of 1991, we had a lot of liberalization policies coming in. Now, it was the Confederation of Indian Industry in December 1995, it set up a task force to draw a voluntary code of corporate governance. This voluntary code of corporate governance was released in 1998, and this is called as the Desirable Corporate Governance Code. The name of the code was Desirable Corporate Governance Code. We had a Companies Act 1956. Now, what was corporate governance, or what were the mechanism of corporate governance that was mentioned in the Companies Act 1956? Let's have a look. The Companies Act 1956, it provided a formal structure of governance. However, it did not address the corporate governance problems adequately, such as it neither prescribed any formal qualification, not duties for the directors of the company. There were no difference in the management between the arrangement between the duties of an executive director and a non-executive director. And the focus on the financial reporting, it was rather on the rules rather than on being transparent enough. Then there was no chance of the auditors or the the shareholder relation, the interaction between the auditors and the shareholders. So this resulted in, and it could result in malpractices, corporate malpractices. And then the company, they did not have any provisions redressal of grievances. So this Companies Act 1956 had many lacunas as far as the functioning of the corporate governance was concerned. Now, the Confederation of Indian Industries took an initiative under Mr. Rahul Bajaj, and a task force was constituted, and certain recommendations were prescribed by the Bajaj committee for the CII. Now, some of those recommendations were the board of directors were required to meet at least 6 times a year. A person could not be a director of more than 10 companies. A listed company of rupees 100 crores and above should have a professionally and competent, recognized, independent non-executive director having clearly defined policies. And the annual operating plans and budgets, they had to be incorporated in the annual report. The other recommendation was the stock exchange had to insist on a compliance certificate which would be signed by the CEO and CFO that all the accounting policies and procedures were followed.